not do, he left such a mark, and I'm using him because he's right in front of me. He left such a mark that his work will speak for him. And I find it interesting, I'll end with this as an interesting note. When we returned to democracy in 1999, Gani Fame was one of the people who thought that those who had fought for democracy should stay away from politics. And because we've done our bit, let's stay and watch what is happening and check what is happening. Bola Tinubu, the current president, was of the school that, no, we fought for this thing, we should be part of it. Donald Duke, I believe, was also one of them. So there were a few of them that decided to go into politics because they said, we fought for this thing, and we cannot then leave it for rogues, quote and unquote. Rogues seem to be the theme for this afternoon. We cannot leave it for rogues to then take over. Fast forward 25 years, or not even 25 years. Fast forward a number of years, Gani Fame rethought his position, and he then set up a party, I think NFP, and ran for president. Sorry? NCP, thank you very much. Oh, interesting. Okay, so maybe you can speak to that a bit as well. Femi Falana at some point ran for governor in Ekiti State. But by the time they were running, it had become a...
Very well. Thank you. You've been doing, very well. So you have the opportunity to defend us. Thank you, sir. So, Mr. Malaki Ugwumadu is a notable Nigerian civil rights lawyer, human rights activist, and social commentator on national issues. He was the immediate past president of the Committee for Defense of Human Rights, CDHR, and also served as the former general secretary of the same organization. He was the former deputy national secretary of the Joint Action of Nigeria, that's JACON, that played a coordinated role in seeking for democratic governance in Nigeria after the annulment of June 12, 1993 presidential elections by the then military, I won't call him military president. Here it is stated military president. We never had one. A military administrator in the person of General Ibrahim Babangida, retired. He was part of the robust resistance movement to the repressive and dictatorial leadership under the military junta of late General Sani Abacha between the year 1993 and 1998. Mr. Ugwumadu is a managing partner at Malaki Ugwumadu Chambers and served as a former counsel at Falana and Falana Chambers. The seasoned lawyer is a member of the Chartered Institute of Portfolio Management and also worked as legal advisor, University of Nigeria Alumni Association. Please, can we give it up for Mr. Ugwumadu? Mr. Ugwumadu, please, you can just sit down. No, I will. Oh, I'm so sorry about that. To start. Very well, Mr. Ugwumadu. Very well. So you have 15 minutes to deal with these issues.
Thank you.
Thank you very much, sir. You can use this equally.
I think it's good afternoon, everyone. Good morning. I came a bit lately, so I want to ensure that we don't have that sense of loss of time. Let me start by profoundly apologizing for my lateness. I don't think I can perfunctorily make that excuse, particularly when my Lord Justices are here, judges of the High Court, senior advocates of Nigeria. I've seen a couple of them. That is not to say that keeping anyone waiting is anything to excuse yourself for. So please, let me keep it that short and appeal that I should be forgiven. The reason for my lateness, I do not wish to disclose. Thank you. Considering the seriousness I attached to this whole process, yes, I did not, yes, it was indicated that I would speak together with my co-panelists. But I'm not taking for granted this kind of opportunity, no less when it's coming from my very good friend. He actually contacted me, and I knew this is going to be a serious event. Talking about the learned senior advocate of Nigeria, Olatunde Adejuibe, one of the finest, resourceful gentlemen, not just gentle, genial gentleman of the bar. I thought we could clap for that. If there was anything I wanted to do, it was to be sure that I don't disappoint him. I have a 23-page address here, but I'm not going. I checked again and found it was office. It follows, therefore, that this point about only qualified legal practitioners are to belong to that organization came up in two distinct cases. The one is Tijani Good Practitioners Act. A person is entitled to practice as a barrister and solicitor if and only if his name is on the roll. Now, I took the time and the practice of their profession. It didn't make as much commitment. Please, I wish we could read it. Not much time, I would have read out the 14 aims and objectives. Not much commitment was expressly made in relation to the commitment of this critical stakeholder and professional body to the ideals and development of the state. When I say state, I mean the country within which they practice. In fact, I do remember that Femi Falana, SAN, my principal, my auditorium, Faculty of Law, that is Adekunle Ajasi University, in 2010, reminded everyone that even at the creation of the Nigerian bar, when it was founded around 1950, there wasn't much commitment and dedication to the struggle of and survival of the nation itself, as much as it paid attention to the practice and members. I'm sure many people will be wondering now, why would an association created for its members, designed to deal with the exigencies and challenges of its members, begin to worry itself about its commitment to the nation? My answer is simple. If you cut the tree and continue to cut the tree and refuse to watch the direction of the fell, when the tree falls, you might be the first victim. Somebody said exactly, please say it loudly. That will be the force of your conviction. That is my conviction. And I am almost bold to say that that is about where we find ourselves, because, as it were, we have literally abandoned this critical aspect, not just to the politician, but even those whom we are better off in terms of education, in terms of learning, in terms of knowledge. 14 years ago, when he made these remarks, he pointed out that, yes, that's enough time. He pointed out that in spite of these faulty beginning in his assessment, there were very progressive elements within the same association, led by the Chief Obafemi Awolowos of this world, H.O. Davis and co., who took active part in the nationalist struggle. In fact, H.O. Davis was a member of the defense team of lawyers who stood for the Mau Mau fighters in Kenya. Our own Alao Aka Bashoru collaborated with Kwame Nkrumah of Ghana in the struggle for decolonization of the African country. Regrettably, as an association, we stood by. Even when transgressions were noticed and suffered by the colonial regimes. Now, concluding on his thought, he said, in spite of the special placement of lawyers, I'm going to move faster now, and the timekeeper has approached me. The socio-economic matrix, the NBA distanced itself from the anti-colonial struggle of Nigeria, even when political independence came under threat in the First Republic, and some of its leading members became victims of state repression. In NBAs failed to speak out in defense of that human right. Now, let me skip this and answer the question I posed about the People's Bar or just the mere professional body. So, at the end of the day, and by the way, this is a wonderful one. We have all witnessed the National Judicial Summit, which was just concluded less than a fortnight ago. The sister branch, the Lagos branch, has also dealt with issues around justice reform in the justice reform. And the fact that this is going on now tells me that there is a fresh consciousness around the need to reposition and adjust our relevance in this whole campaign. Now, let me quickly say that for me, and I hope a lot more people will disagree with me because it has been challenging. What we need in our country is a system that will be sustained by that age-long people recognized as the judicial judges. Many of them are here. I'm talking of those who are described as the judicial activists. They cannot and will not actualize all of these except there are activist lawyers. Lawyers who are propelled by the need to add value and, effect reforms within their country. Because that is the only time the judges that are disposed to act will have the opportunity to interpret the law as it should be and as it ought to be. Honorable Justice Akinola Aguda, of blessed memory now, had this to say, even controversially. And that was in the convocation lecture titled Quintessence of Justice, which he delivered at University of Maiduguri on January 31st, 1985. To the best of my knowledge and experience, there is nothing like equality before the law. At least not the way the law operates today. It is nothing but a myth created by the political rulers and the lawyers to give cold comfort to the common man so that they, that is our political rulers and the lawyers, can have a peace of mind in this country of ours. We are not equal before the law unless we want to give a restricted meaning to the word equal. I'm sure that coming from a renowned jurist as we knew him will jot many of us and pose the question directly whether indeed most of the doctrines and principles that we have held on to over the years do not deserve reforms and radical changes. Now, I have a very thought-provoking statement along this line by the Cicero himself, talking about Honorable Justice Chukwudifu Oputa, who at the first Justice Idibia Memorial Lecture at Obafemi Awolowo in 2024 remarked as follows. I hope we could hear this. He was delivering a lecture on judiciary, the common man, and judicial activism. He says, and I quote, "The main function of the judiciary is the administration of justice. Today, however, justice have come to acquire an enlarged meaning and connotation. When we speak of justice, we mean not only the commutative justice, but also the distributive justice. We mean human justice. We mean social justice. It is not justice confined to the fortunate few on the apex of various pyramids of power, if you like, centers of power. But justice which takes within its compass the large masses of the underprivileged segments of our society, the much and long neglected common man. When we speak of justice, we mean justice which will penetrate and destroy all irregularities of ethnicity of power, of wealth, and of position. We mean justice which will bring about equitable distribution of our vast resources. And that reminds me of what we have rights in our Constitution, Section 16, subsection 2B, C. You could say that that is under the fundamental objectives and it's not justice. Well, what we have decided to do in the community where I operate is that if you continue to fold your hands and say that it is not justiciable, it's not justiciable, you will even foreclose your thinking processes. What we have decided to do, and which has been happening, is to even take each and every aspect of those rights, which are the most important rights. I do not know what you'll be doing with your freedom of education if you are not educated. The fundamental objectives and directive principles create rights and privileges like rights to education, shelter, pension, even the minimum wage that we're talking about today is there in the Constitution. It doesn't talk of minimum wage. It says workers are entitled to living wage. Please read the Constitution. So what we do is, okay, since we are now, or we've been caught in this dubious environment, where you give with one hand and take the other one, let us start the campaign, the agitation for the actualization of these rights that gives the foundational, the provenance to the enjoyment of even the fundamental rights. So we take education, for instance, the Child Right Act came, isn't it? That Child Right Act is a revolution. When you hear about the Freedom of Information Act, it didn't come from any executive bill. It was a function of campaign and sensitization and crass determination to demobilize the ruling class in their mischief to continuously hold us down. That bill took how many years? Almost, 12 years, 11, 12 years. Meanwhile, the one with which they gratiate themselves are a matter of hours. Yes. Those who suppose say, yeah, that year. So, Justice Chukwu Defu-Oputa, in his very reverberating moment, said, we mean justice which will bring about the equitable distribution of our vast resources. It is the duty of the judiciary to ensure that this social and distributive justice is available to all. It is the duty of the judiciary to fight against state lawlessness and abuse of power, and to fight against the promulgation of harsh, oppressive, and draconian laws. A timid or an conservative judiciary cannot do all of this. He concluded by saying that to this end, our judges should be motivated by a dynamic, progressive, and forward-looking philosophy of law. That Austrian stage of positivism, where the law must be the law, and not the law relevant and applicable to the moments of the day, should be a thing of the past. There has to be an enlightened approach to the social and development engineering of the law. What our judiciary urgently needs is a new humanism and a well-founded and growing concern of the civil liberties of our people. Law should never be an end in itself, but merely a means to an end. I will not bore you with so many profound. In my own case, I'm sure she said, it's okay. In my own case, and this is with all modesty, Malaki Ugumado and another against the University of Nigeria, where I spent approximately 10 years studying the courses that you did for just 4 years. Or 5. Thank you. And therefore, we cannot, on the basis of that, proceed. My Lord had this to say: fundamental rights have to continue. It has to continue to be enforced until whenever the Chief Justice of Nigeria makes such rules of procedure. In my view, since no such rule has been made, and since it is not the desire of the law that a vacuum should be created in the circumstance, or resort to the inherent power of the court, fortunately, I have found one. That such saving provision is section 315 of the 1999 Constitution. And he read out what that means. In particular, and I think of interest, is section 315, subsection 4b. It talks about even the rules of court. Any law, and includes any rule of law, or any enactment or instrument, whatever or whatsoever, which is in force immediately before the date when the section, that is section 315 of the Constitution, comes into effect. In my humble view, the fundamental right enforcement procedure is one of such enactment within the meaning and intendment of section 315. I think I just need to summarize, since I committed the crime of coming late, to say that another way by which we can appraise what our responsibilities should be as a bar is the long struggle against the local standard, for instance. It took a very long time. In fact, and it drew energy from this whole passive and present case, and how that constituted a very big problem for ventilating our rights and privileges even under the Constitution. Once that red flag of local standing was raised, it became a serious issue, notwithstanding whether you had merit in your case. The Olawi and the Attorney General of Northern Nigeria will remember all of those. Until we began to see some tendencies to reform or reverse this trend. And in this regard, as I rush over these papers, we all remember even the recent case of Fawemi and President. Now, when you juxtapose that with the approach of the same issue in other Commonwealth countries, you would see that there is a need to not just to borrow, but to collaborate with the kind of judicial system and their receptiveness to the actions of citizens of this country. In particular, I referenced the Inland Revenue Commissioner and the National Federation of Self-Employed and Small Businesses in England. I went to India, Pakistan, Bangladesh, even Uganda here, and highlighted cases, one after the other, emphasizing the point that for as long as the rights exist, the remedies must be found. I hope we are all familiar with that maxim. Ubi jus, ubi remedium. Now, all of these rights are no longer just municipal rights. We have had these rights also domesticated in so many in so many international instruments dealing with the rights of member states. Now, the Fundamental Right Enforcement Procedure 2009 makes a radical departure on issues of local standing. I hope we're all familiar with this. And introduced very receptive and progressive position regarding the enforcement of this right. Finally, before she gets to me, I therefore propose, but I hope she allows me to make this last point, that we're all in this business. I had once told a judge, and that was with profound respect. I had brought the federal government had abolished the use of tinted glass. I don't know if you remember, through the police, the Ministry of Police Affairs. And in that public release, they only said president, governor, deputy governor, speaker of house. And I searched carefully. I didn't see my name there in that exemption. I just told you how at the age of 22, 23, I had gone to court twice before I graduated, challenging why the university should behave in the way and manner they. I know my age now. Where is Malaki in that exemption? Have I become a lesser citizen of this country only on account of the fact that I'm not a public office holder? My Lord Justice Okechukwu, he was retiring then. They decided to give him the. He said, Bestugumado, what is your problem? Why are you complaining? How does that become a problem? I said, my Lord, that right that everyone has to life, in the same way they bear those rights, they also have a right not to be discriminated against. And if they have refused to complain because perhaps they didn't fight for this right, I have approached you. I didn't go to the shrine. I have approached my Lord to activate that right in a manner that reinforces my conviction that I'm a Nigerian. I don't want you to ask me whether I won or I didn't win. But the problem is that we need to watch it.
We're lawyers.
On this cross to the other side, they should go this land. I did ask that question, whether we're not tired 6 years ago. And the reason is that, because I don't want this to be just a talk show. Most times when we come together, what we do is to talk. But there's another thing that you said immediately I stepped in about not wanting lawyers to be. I want to let you know that as chairman of the branch, I've been caught in that situation where I did not want my people to go out and be seen like, that lawyer that. But that appears to be the language that they understand. The last time our member was brutalized at one of the stations here in Lagos, we were at the command here, just the command here. And the first thing they did to us was to tell us that we should leave our phones outside. And I asked, why the public? And they said, no, you have to leave your phones. And I said, we can't leave our phones. And they said, no, that's how they do it. I said, okay, sick, did say. Some of our colleagues were already complaining. IKEJA, you have come with your problem here. My colleagues, my brother chairman, they thought, look, you can. And sometimes I appreciate the fact that you took your discussion from that angle. We're tired of talking. We keep talking and talking. Next year, law week will come. We will talk. We're really tired. But the question is this. What do you think we should do? I don't know whether you said that when I stepped out. Please, what is your own advice? Thank you.
Yes, that question is for Mr. Damalekun, and I would like Mr. Malakai to also take that question. So, Mr. Damalekun.
We're in very dangerous times, and I don't say that to be alarmist, but I say that just because it's fact. And it's fact because when you have a government in office that not only knows the rules of the game, they've played the game. During the 12 dinner, Sheikh Usani stood up and talked about how Bola Tinubu has a history of protest because he was in opposition in our journey to democracy. So he understands the terrain of opposition, he understands the terrain of protest, he understands a bit of the mindset as well. And so you have a lot of people in government that are technically progressive. Chidi Odinkalu, again, my favorite legal troublemaker, has a tweet, I think, a day or two ago, where he had the cover of the news that talked about Nigeria being sold to the Shaguris. He then wrote in the comments, he now said, does anybody know who the editor of the news was at the time this cover was done? The editor of the news at the time was Bayo Ononuga, who is the current spokesperson to the president. Now that just gives you context for what we're dealing with in Nigeria today. We also have a National Assembly headed by one of you, who, number one, should not be a sitting senator of the Federal Republic in the first place. But again, one of you made that possible. And not only that, we now have a National Assembly that's literally in the pocket of the executive. So we have a legislative arm that's in the pocket of the executive. We have a judiciary for all intents and purposes. Even though I think someone spoke about the AG, I think it was Mr. Malakai talking about him, and in fairness to him, he's pushed back on a number of things that he disagreed with. But as a whole, the judiciary as well, because it's complicit and complacent, is also silent. So you have an executive who not only believes they can, they continue to push the boundaries just a little bit every time. And it reminds me of the proverbial story of a frog, who you put in warm water or cold water, boils rather. The frog adjusts because it's burning gradually, it's boiling gradually. It doesn't, if you drop a frog in hot water, he'll hop out. But if you put a frog in warm water, put fire under it, and it slowly begins to boil, his body temperature adjusts until it cooks. And that's where we are. So I say all that to say that I completely agree with the chairman when he talks about sometimes in a situation, let me not say sometimes, in a situation like that, what power office of the president and the office of the governor might be very antagonistic, because I just didn't believe that government meant well for citizens. So when I approach people in government, I'm very antagonistic. Now I'm a bit than deserves. And so as long as we continue to give them deference because of the office they occupy, but forget that in the office that they occupy, they're denigrating that office, there's no incentive to do anything different. He will come in, we will greet him, he will sit. In the midst of all of that, he'll say what he has to say and then conveniently have to dash. He will just do the, what do they call that thing, keynote, opening remark and say, so sorry, I really have to go, and then leave. So no feedback, no comment, he doesn't get to hear anybody else. So again, I'm saying all this to say that I agree with the chairman that the language in a situation like this is sometimes needs to be a bit antagonistic. But I'm saying that for those that might not have the temperament, because I also recognize that it comes with a certain temperament, all this does is that memos do come before your table, refuse to sign it. You are a lawyer that someone comes to do this, say you can't. I'm sorry, I can't. My office does not believe this is right. We won't do it. At the end of the day, if you have 10 lawyers and 9 of them say no, the one that says yes then becomes the black sheep and then becomes much easier to point out, much easier to talk about, much easier to ostracize, much easier not to invite to functions, much easier not for them to begin to feel uncomfortable. We've gotten to the point as a society, and obviously it's a law week, so I'm talking to lawyers, but as a society, where as human beings, we don't have any shame anymore. Just as human beings, this is not about lawyers or doctors or any profession, just as simple human beings. The things that people will be ashamed to have their names associated with, now is just par for course. Because why? We will move on. And again, because there's no consequence. There's no consequence in feeling ostracized, in yourself or your children not being invited. Because my mother will tell me the kind of children that can't hang around. Because they come from, in her words, a home that doesn't reflect what I want you to have. So they cannot be your friend. You can meet in school, but to go home, then it's not happening. To go and say you are going to visit them at home and not under my mother's watch. But all that did was to tell me that there's certain behaviors and practices that are just not right. And partially, sometimes, this is when I'm in primary 5, primary 6. It's not that the child has done anything. But my mother is clear that the parents breeding that child or raising that child have values that she doesn't agree with. And she doesn't want me mixing with them. Okay, before I turn this into a lecture, because I do have to run. But just to the point, what can we do? Honestly, it's not like if all of us in our personal spaces, at home, in churches, some of us have staff, we have drivers, we have people that work with us, in what we do in front of them, how we engage them, in our churches, in our boss, in our law practices, in our professions, just deciding that, you know what is it that I'm doing that if it is said of me that I will be proud of, to say, yes, I gave that judgment and I stand by it. I represented that client. Now, also, lawyers are also a bit tricky because you have to be on both sides of the divide. But there are some things that are just, in the interest of Nigeria, just not working. And be able to stand up for the interest of the nation state that we call Nigeria. There's some things that I just will not do. Because ultimately, if we all take personal responsibility for our actions, without a shadow of a doubt, I do believe we'll have a better Nigeria. Good chooses to be silent. Thank you.
Thank you.
Difficulties and challenges. And in my view, that is what enlightened, knowledgeable, professional, educated bodies like MBA should be. Come to think of it, we are just about going into election now. And I've been listening, or rather itching my ears to hear what exactly the candidates, some of whom, my classmates, 2 others junior, a year junior. When I remember what I went through to become a lawyer, and find out that you could come to that justice sector and you can be frustrated by not fellow lawyers, but people who actually perhaps dropped out of school. It's the pain in that is another level of pain. To what extent do we restore our dignity as an association, bar association, when we are not subjected to many of the things we go through, which I will not want to bore you with. Chief Ganifa and me, whose photograph is there, told me something in the heat of the struggle against the military. He was the chairman. I was barely 24 years, driven away from the university, no degree, no certificate. I'm a twin. My twin brother studied in the same university just as myself. Graduated with a certificate. I graduated with Wahala. Now, but here's the point. He said very closely, he said, the very moment a slave refuses to be a slave, he ceases to be a slave. A slave ceases to be a slave the very moment he refuses to be a slave. That struck a chord in me because he had warned that the strength of whoever oppresses you lies in your own weakness. Whether it's the military, whether it's a draconian government or an oppressive, whatever. I would appeal that what we need to do, since we are looking at the things, I'm sure of this generation, which was why some of us were very excited during the NSAS protests. Well, we saw violence, we saw all manner of things, but there was a statement about the renaissance, the reinvention, the will and capacity and possibility of the Nigerian youth in that exercise. I participated in the tribunal. There is no better gathering, no better formation that can properly interrogate all of
like someone said. I remember when we were at school, I was in school with Malaki. Yes, and we were just two female students that were members of CDHR, Chinedu Agwaramba and I. For those cases that he was going in, I followed him, and it was so unfortunate. Do you know why? Because the lawyer representing the school, Ejikume, SAN, I was Chinenyume, he was my uncle. He will go back home. You remember Malaki? He will go back home and tell my father, your daughter that you sent to school is becoming a rebel. My father was almost withdrawing me from school, but we persisted. We continued in that case because we dared to make a difference. I remember a friend of mine, Chuks Okonkwo. Chuks Okonkwo was on his, you know why I'm bringing up this thing? Is whenever you find yourself, you should try to make a statement and make a stand. That is taking a stand. Chuks Okonkwo was on his way to the island, and police, commissioner of police or whatever, he was coming in a convoy, and he was doing one way. Chuks Okonkwo blocked the road and told him to go back. Oh yes. He got down from the car. His men took their cars and their guns, and they wanted to flog Chuks Okonkwo. Chuks Okonkwo insisted that they must go back. Do you know what the commissioner of police did? He told them, let's go back. We don't know this is a madman.
Good afternoon, everybody. I stand on the existing protocol. Well, I am representing the Chief Judge of Lagos State. We are glad this kind of topic has been raised by the IKEJA branch. And I'm sure we get more lawyers to enlighten the public on what their rights are and what we are supposed to do. Thank you.
Thank you very much, my lord. And in the absence of any more questions, additions, okay, I think we have a question, sir.
Mr. Chairman, let us sit here present. I stand on existing protocol. My name means Bartholomew Adudu, the immediate past chairman of the branch. Mine won't be more of a question. It will be more of a and my reaction or intervention, as it may be, comes from this space. What lawyers should do. I will start with a question. How many lawyers will be going on the road and see somebody be beaten up by a police operative and abandon his journey to address that issue?
That's my role.
In a hall of almost 150, less than 10 persons raised their hand. And you are asking, what do we do? We have to start from little things. It doesn't only have to be when a lawyer is there making people know what is right and what to stand for. The exercise will be an exercise in futility. We all agree that nobody is a Father Christmas in legal practice. So you didn't go to school to give free services. But again, we are the voice of the voiceless. And if we remain the voice of the voiceless, we can only ensure the rule of law drives by making little things around us matter. And that is the big question. In the compound or in the building where you live or your neighborhood, there, are you identified as somebody that your community will run to if there is an operation in the very area? That is what lawyers should do. We may hold symposium and continue on and on with our speech, but except we walk the talk, we may still not get anything done. And the police, that was a very sorry sight we had by my two. A bus conductor was standing by the bus, which is against the law. He chased. In the point of chasing him, they knocked down a bike man who died on the spot. When they brought the bus conductor down, 4 of them were carrying him like a corpse, with those kicking him. And I was on my way to court that very morning. I was forced to stop and I asked. They said it caused the death of a bike man. I said, no. You people killed a bike man willfully. I called my juniors in the office and said, take the matter in court. I will follow them to Area E Command there. When we got to Area E Command, I met the area commander and told the area commander what actually I saw and what happened. He said, default all these policemen on ground here. What the conductor told me, Oga, God bless you. If you had not been here, my journey would have been a long journey. I think if we have to walk the talk and we take it upon ourselves that we need a change in the environment we start, our immediate environment will matter most. Thank you.
Okay. We are now having questions or an addition. Okay, I think we can only take 2.
Yeah.
Okay, we'll have you, sir.
May I be given the opportunity to stand on the existing protocol? I'm Enakadia Daniel Ovigo. I feel that our profession, the laws guiding us, the Legal Practitioners Act and the rule of professional conduct is not loud enough. What I'm asking for is for us to have a push into the Constitution of the Federal Republic of Nigeria, whereby lawyers could be given the opportunity to have an in-house redress, be given an in-house opportunity to given internal disciplinary trials or whatever before being dragged to the court. Instances where lawyers are beaten up, maltreated, killed is very embarrassing and painful. Because you can't just pick up a policeman and punish him unnecessarily. You can't pick up a soldier and punish him unnecessarily. Internal disciplinary measures. So these are the things that are pushing me to say that and push for a bill for an act so that we can find ourselves in the Constitution. Thank you.
Thank you very much, sir. We are going to take just one more question or addition to all the comments we have on ground.
Yeah, good afternoon, everybody. I stand on a call. Like I said during the press conference, the public is in troubled times. They are really in troubled times. Safeguarding the rule of law in Nigeria, when you analyze the topic, you know, the anatomy of the topic is wider in scope. And at these junctions, I want to ask a question. I also want to say this, that both the bar and the bench, both of us are drinking from the same fountain of justice. Now, can you ask yourself as a bench, as a judicial officer here, and as a lawyer, is your fountain of justice flowing to protect the masses? And as a BAM material, can you ask this fundamental question, that is the fountain of justice also flowing to protect the citizen? And I say that even the fountain of justice for the present situation in Nigeria is stagnant. It's no longer flowing. People are now afraid that even if they call themselves a lawyer, personally, I'm tired. I'm tired of this profession. I'm even afraid to call myself a because of the father serve in Nigeria. And I said something during the press conference that may we never get to a stage. By the time you introduce yourself as a lawyer, they've started beating us out of the road. The rule of law is not only to the government or condemn lawyers. Even he said that, he said something when he addressed us that when I see people being maltreated by police, as any of us have the stop and say, come on, please stop what you're doing, officer. They will even ask you, who are you? Stop what you're doing, it's illegal. When people call me yoga and they fire me, sometimes I say, God, when I see things on the road, a number of times I jump out of the car and say, come on, to challenge what is challengeable. In a whole that corner, even at the bar, in your own association, do you follow the constitution of your own association? We are talking about the rule of law. If you cannot beat them, do you say, no, I don't see trouble, let me join them because if I cannot be there. I think that this also put the rule of law. We must make sure it is true. Apart from it is true, you sustain your position. You cannot join them. Make sure you what is right in order for us to promote the rule of law in our dear country. And I have a dream. We are going to have a new Nigeria. It might take time, but soon we'll get there by God's grace. Thank you very much.
Thank you very much. That marks the end of this session. I think we should all give a round of applause to our panelists, Mr. Malakai, who's here. And I want us to give ourselves a big round of applause for being a very well-behaved audience.
Yes, I will say that.
Okay, yes. Milords. Milords, thank you very much for your presence. We are deeply honored to have you with us. Thank you for all your guidance. I can see my boss, Justice Oshoala. Thank you so much for being here. Thank you very much. So I'm going to hand over to Yemi. This ends my own session.
Very well. Thank you, Bumi. It also follows that the Honorable CJ has been ably represented. So that goes a long way for us as MBA IKEJA. And that will just take us to the end of this particular session. We have another session, just as a form of information, that will start at 2 p.m. May I be guided, please? So, on the program of events, or probably on the program booklet, it is 1 p.m. However, because we want to create more like a break in between, that is why this event will start at 2 p.m. Oh, okay. So we are expected to convene here from 1:30 while the event itself, because some of the speakers are already in-house. So please, we apologize for whatever inconveniences might cause us. However, in closing, we'll have a close. So in closing, before we round off this session finally, we have a token of gifts for our panelists. And we shall be doing that to the panelists here. May I respectfully, Delta, so to speak.
So, without wasting time, Mr. Malaki, you are a member of the branch, and then you do us proud every time. Thank you very much for honoring us. God will honor you. Thank you very much.
Okay, that seals it. And I'm going to invite the chairman of the NBA IKEJA Law Week 2024 to please kindly do us the honor of having the vote of thanks for this particular session, after which we can now, once again, finally close the session. Thank you, sir.
My Lord and distinguished colleagues, on behalf of the executive of this branch and the Law Week Planning Committee, I want to say we appreciate all of us who have turned out for this session. I'm thanking my Lord particularly because we know you have had to put aside some pressing duties to join us. So we're really appreciative, and we thank you for being with us. Distinguished colleagues, well, I can only say a partial thank you, but you will get the full at the end of the second for a while, because we are mindful of the fact that some of us will have to have some lunch and snacks for a few minutes before we reconvene. But let me quickly tell you the topics for the afternoon sessions are sessions you don't want to meet. We are talking about the consumer protection, and then we are talking about competition law. And these are essentials. The GM of LASCOPA, Lagos State Consumer Protection Agency, is already around, is on ground now. So the number of things on a daily basis, now you are already reading about cholera again. So that sends us that these are areas that all of us must pay attention to. And then, of course, we'll be dealing with competition law as an area of interest for legal practitioners and all the opportunities that are bound. Please don't miss it. Thank you very much.
Thank you very much. Can we give it up once more for Mr. Ogumadu? Thank you so very much for your time, sir. So can we have a photo session? The honorable judges here present, please. You have to be. I have an order of court that says you cannot leave until that picture is taken. I know you can see two. The order. So can we come? My lords, can we have the honor? Yes, sir.
I hope that will not be a basis to recuse ourselves.
That means a lot, actually. Thank you very much. So, learned colleagues, kindly hold on while we allow the honorable judges exit before we step out of this hall. Please, can we clear the hall? Hello, council. Did